Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live weekly broadcast for the 11th of May, 2023. I'm going to try to keep it a bit short, but I think I'll do, say, 4 issues on the list of things that I have documented, or I think I have documented. And I might discuss a few horror stories that, occurred to me. Like, if I do, I'll tell you about some veterans I've been trying to help that I think the government has acted very atrociously. Anyway, number 258, the Pension Act, Section 25, and how contributory items were treated under the law, and how was the Manuge case treated for Section 25. Now, Section 25 of the Pension Act is the clawback section. That claws back 2 different things. If you get a pension for an injury in your military service, and you also get compensated by a tort damages award or a workers' compensation benefit type payment for the same event that caused you to get your pension, then the government wrote a law to make sure you wouldn't get doubly compensated for the same event. And there's nothing wrong with that in principle, except for the fact that who says that the government of Canada should save? Why might it not be the people who had to pay damages in tort, or the people who had to pay workers' compensation? So obviously each side would take their own side, and the government wrote a law to exclude the judge's judgment. So, do they have that power? I don't think so, because Pension Act Section 90, Constitution Act Section 9213 assigns property and civil rights to the provinces. Now, if you give property and civil rights, which includes the right to sue in tort, and which includes labor, workers' compensation came about because of the exchange of the right to sue for the right to compensation. Now, the government wrote a law that I think is unconstitutional, but it rarely gets used anyway, so it really might not matter in the long run. Now, the problem is, that is a pretty good exception to the rule when they say that a payment that is contributory is not to be subject to clawback. So that was the reason why the government never went after the Canadian Forces Superannuation Act and tried to reduce the pension by the amount of the Canadian Forces Superannuation Act retirement pension, or the Canada Pension Plan. Disability or retirement, both are contributory. Now, the Service Income Support Insurance Plan is also a non-indemnity and contributory insurance plan that the Canadian Forces member contributed towards. So therefore, under the law, the government could not touch it. Now, here's an interesting fact, at least to me. That law mirrors the common law. In the common law, if you get damages after someone injures you and you have private insurance or a pension, then the judge won't let them take that into account and claw back the value of the money that you receive in damages that is supposed to restore you to the place that you were before a person harmed you. Well, insurance doesn't count. It isn't compensation. And neither is pensions. So pensions and insurance are part of a rule called the private insurance exception rule. So if you buy insurance or save up money in a pension, that money is not supposed to go to somebody else's benefit. It is supposed to be to your benefit. Okay, number 259. Contracts require ratification when large numbers of people are involved, such as a union contract. Where was the ratification for the SISIP policy? 901-102. So there's a couple of things that come to mind, and today I was looking through some of my old photos and I was trying to recall certain things, and up pops this case, I think it was from 1990, talking about the fusion of two principles in contract law, talking about freedom to contract and privity of contract. Now, you are not supposed to make a deal you're supposed to make a deal with someone you choose. So the government in 1982 got rid of freedom to contract because from 1969 till 1982 there was freedom to contract in that a person who was in the military did not have to buy SISIP. It was voluntary. So that satisfied the rule about contracts, saying that you have to choose whether or not you want to enter into a contract. But in 1982, the government passed or wrote or whatever, Queen's Regulations and Orders 208.53, and they started deducting the premiums for SISIP directly from a soldier's pay. They never thought anything of it, but they were breaking the common law because people have to have a choice. A lot of contracts, most, if any, all contracts of insurance are take it or leave it, which is legally called, an adhesion contract. So you walk into an insurance company's office, they tell you about the deal, you either take it and pay them money and sign on the dotted line, or you leave it and you walk away. Now, the government took away people's choice in 1982. I was 16 and in high school, so it didn't really matter to me. But here I am talking about it, and they ought not to have made it mandatory. It violates an important legal principle. Now, the other principle is that privity of contract says that only the parties to a contract can get a benefit. Well, you can give a benefit to a beneficiary, but you can't impose a burden on a third party. Okay? And that's related to the fact that a third party who never had a choice about the terms of a contract can't be bound by the terms. So when you look at the SISIP policy, on paper it's the Chief of Defence Staff has a contract with Manulife, and the Canadian Forces member is not a party to the contract. Now, if that's the case, which it surely is, then you can't impose clawbacks on that person because they didn't sit down and negotiate with either the Chief of Defence Staff or Manulife. They had no choice about that term. So they imposed a legal burden on the disabled veteran, and you can't do that legally under the common law. You're just not allowed. But they have been doing this because they have been avoiding letting us know that Manulife is not really the underwriter, that Manulife is the administrator of the policy for the Government of Canada. So because the Government of Canada is the insurer and Manulife only administers it, then when you get a payment, if you're on this insurance, you're not getting it from Manulife. Well, you kind of are, but they're doing it on somebody else's behalf. And because they're doing it on somebody else's behalf, well, you're getting paid from the Government of Canada. And that's what came out in the Manuge case. Now, it's kind of crazy how this has been a hot potato. I mean, 1969, I assume it was Maritime Life that was the underwriter. And then in 1982, Treasury Board Secretariat assumed control of SISIP. Then in 1991, the Chief of Defence Staff assumed control of SISIP. Now, when they did, seeing I was talking about negotiations, McInnes Cooper had a copy of the letter from the 31st of March or the 1st of March, 1990. And they had Maritime Life and the Chief of Defence Staff, and they came to an agreement about the Chief of Defence Staff assuming control. Well, it's almost like a contract because they had signatures on it. Unlike the soldier, the Canadian Forces member, who doesn't have a signature from their union, which they don't have, or themselves, about accepting the terms of the policy. Now, getting a bit dry over here. Anyway, number 260. Sun Life / Manulife and Canada Pension Plan Disability. What share, if clawbacks were legal, would or should have taken place in my own case? Now, I've repeated myself so often about this, I'll tell you again. When I got approved for my Canada Pension Plan Disability, after my 4th application, without having the minimum qualification period, I was approved unlawfully. Well, Sun Life, they started taking the amount off, which was $1,017.94, but I'll say it's $1,000 for simplicity's sake. Now later, Manulife started taking off $1,000. Now, for the $1,000 I got in Canada Pension Plan, I lost $2,000 off of my insurances. Then, not to be outdone, the Public Service Superannuation Act took $500 off. At least it wasn't $1,000, but it still hurt. And then the Reserve Force Pension Plan took off $50 a month. That's not much, but I was only getting $200, so $50 is a fair chunk of it. Now, altogether, I lost $2,650 a month. When I got $1,000 to the good, I was down $2,650. So I'm down $1,550 a month since 2015, 8 years ago. Now, as a backup plan, I said to myself, and I said to these assholes, I said, listen, guys, you should ought to know that you can't take more than what I got. So that brings up the question, who would get to share the $1,000 up between those 4 entities? Okay. So I was with CRA, the government really. I was with Indian Northern Affairs Canada first. Then I was with Canada Customs and Revenue Agency. And then they became the Canada Revenue Agency. So I was with the federal government since 1991 up until 2012. So that was 21 years with the federal government as a civilian worker. Now I joined the military in March 1999, and I got out in 2012 again, same as the CRA. So I was there for 13 years. Now, obviously they shouldn't be split up equally, because I was with my civilian employer a lot longer than the military. Now, that's one point I'd like to make. Now, the next point is the Public Service Superannuation Act. While I was paying into that for 21 years, and the Canada Pension Plan, I was paying into that for 21 years, and the Reserve Force Pension Plan, I bought back my time from 1999 to 2007, so I bought back my 13 years worth of service. Now, it probably wouldn't be, even if they were allowed to do it legally. By the way, they're not. Okay. Why do I say they're doing it illegally? Well, Canada Pension Plan Act Section 65(1) works with, on paper, Financial Administration Act Section 67, and those 2 laws, federal laws, make it illegal for anybody to intercept the Canada Pension Plan. Now, they will say, we're not intercepting it. We're merely taking it into account, and that didn't work out very well for the government in the Dennis Manuge class action. They said, we're not taking it. We're merely taking the Pension Act into account for the Service Income Support Insurance Plan. They lost. I don't care why they concocted some reason, some bullshit reason to say, oh, the pension is not income. Forget it. They didn't get to take it into account, despite the fact they said they didn't take it into account. They were allowed to take it into account. We're not taking it literally, because really what matters is the effect. Not what you call it. Like, what effect does it have on the person when you're doing something to them? Right? There's cause and effect. So they had it in the contract that they could take the Pension Act into account, but the government put into the Pension Act Section 30 that said nobody could touch it. See? So that's the same law as Canada Pension Plan Section 65(1). So the government has all these laws they wrote, like Canadian Forces Superannuation Act Section 83, Canada Pension Plan Act Section 65(1), the Public Service Superannuation Act Section 10, brackets 10. Now, all of these laws say, hands off, if you want to intercept, you want to legally take this money, you can't do it. But when the government wants to take it into account itself, it ignores the law it wrote. Now, see, that's dirty to me. That's evil. They had a choice about it. They could have left the law a loan. And then if you owed money and you didn't pay it, then the person could go to court, get a judgment, send a judgment to the pension people, and then they would intercept your pension legally because they went to court and they did it by the book. So the government, in order to stop people from doing that, they put illegal prohibitions, legal prohibitions in the law to stop creditors from taking your pension, your insurance, things like that. And there's very good public policy to do that. Because if people have creditors take their money to satisfy some capitalistic legal debt, then the public coffers, the taxes, are going to have to pay for that person to get welfare because the insurance and pensions they had are being intercepted to pay some creditor. So the government wants to avoid having to pay higher taxes because of that. So they wrote laws to protect the money, which then protected the government itself. I didn't read that anywhere, I don't think. I just came up with that solution myself. I'm pretty sure it's plain and obvious. At least it is to me. So, I mean, I was getting all this hassle from Manulife. Like they said, oh, we're going to keep 100% clawback in place until you let us agree to let us talk to Sun Life, and then we'll drop it down to 50%. Now, see, that's what I was saying before. Why should Manulife get the benefit of 50% when I only had 13 years in the military? I had 21 years in my civilian employment. You want to put them together and divide it up, then maybe they should get 30 or 40% if it was legal. Now, the public service pension, they're the same thing. So by the time you look at it and try to figure out who should get what, the real answer is they're not supposed to get anything because they're not allowed to. Not only is it illegal in the common public statutory law, it's illegal in the common law. For example, what I was saying in the first point I mentioned about Pension Act Section 25, things that you contribute to and you save up are not allowed to be taken into account to reduce damages. Boatworley versus Flanagan, Ontario Court of Appeal, 1973. The judge said, words to the effect, I do not know of any equitable principle that would allow a tortfeasor, that's the person who did the person wrong, to gain a benefit from the injured party's savings, pensions, and insurance. He just stated the Barbarian rule a different way. Because it just isn't fair to allow somebody, and don't get me wrong, it's not a person, it's an insurance company having to pay the money because people buy liability insurance, okay? You look at cars, automobiles. The government made laws because they knew people would go bankrupt or wouldn't have enough money to pay damages to people. So they made laws say you had to have insurance to drive on the road. They're trying to protect society by making sure you had insurance. So when you see a case like Cunningham versus Wheeler, it's not Cunningham versus Wheeler, it's Company A versus Company B's insurance. Really. And that case was about long-term disability being allowed to be taken into account off of damages. And the argument was that they didn't pay for all of the insurance, so therefore they should be allowed to take it into account. They lost. They maintained, the government of Canada, the Supreme Court of Canada maintained the private insurance exception rule because you pay for insurance, you sacrifice some of the money that you could use in the here and now. You could put it into this, you could spend it on that. You bought insurance for peace of mind. Somebody else is not supposed to benefit from the insurance you bought. All the time I'm talking about insurance this and insurance that, you'd think I'm getting paid by the insurance industry. I'm certainly not, because them fuckers are out to lunch. Okay, whether it's the employer or the company itself that's doing the insurance, they have all these weird rules that they want people to think it's fair just because it's legal, and they're not looking at the equity of things. When you think about the fairness of clawbacks, for example, even if we ignore the fact that it's against the law, that's where my equity argument comes up. How is it fair to deduct between these four government entities $2,650 when I only got $1,000 Canada pension plan? Now, as proof of this, I have several veterans that I know where they fixed this for them by not taking more than what they got in the Canada Pension Plan Disability. So they've had ad hoc solutions instead of having a systemic problem across the board, solution to the problem across the board. Master Warrant Officer Dan Mansfield and I think it's Sergeant Retired Gerard Parsons. So in those two cases, the government fixed it for those two people. Anyway, because I want to keep going and get this done. Number 261, notwithstanding equals uncertainty. All laws are supposed to be harmonious, so these type clauses create disharmony. Now, in the Charter, I think there's a notwithstanding clause that the government can ignore the Charter's rules when they so choose. And in the Income Tax Act, there's a few notwithstanding clauses. And even like for the Income Tax Act Section 61F, which is part of, they deem long-term disability and other payments to be fringe benefits. And they deem them, which is sort of like the notwithstanding thing, even though there's no reason for it. Like all laws that the government makes in a democracy are supposed to be reasonable. They are supposed to be able to explain why they have a law in place. So for Pension Act Section 30, for Canadian Forces Superannuation Act Section 83, for example, they'd say that the purpose of this law is to protect the pensioner's property against creditors. And everybody'd say that's a good public policy. Now, the Canadian Forces Superannuation Act, that is forced savings and to attract and retain Canadian Forces members. Roy, Federal Court of Appeal, 2003. That's where they said what the purpose of the Canadian Forces Superannuation Act was. So, when they bring in some of these things like clawbacks under the Veterans Wellbeing Act, well, the Veterans Wellbeing Act is supposed to be about trying to help veterans get better. So how is it that the government wrote laws to claw back things? How does that help a disabled veteran improve in their prognosis? Well, obviously it doesn't. What the purpose of the Veterans Wellbeing Act is really is to not pay compensation when the veteran can afford to pay for themselves. It's basically, at least in my expert opinion, social welfare. And they created this social welfare law in 2006, even though they had an agreement. The federal government and the provincial government in 1998 agreed that the federal government would not delve into the provincial jurisdiction and create social welfare law anymore. But yet, 8 years after they had that agreement, the government wrote a welfare law. Well, you might say that the Veterans Wellbeing Act doesn't pay welfare. Well, think about it. It's a needs-based program. So if you have, like the guy Harold Jones, the manager of the local Veterans Affairs office, said to me, well, why are you applying for rehabilitation? You make too much anyway. Well, he's saying that you are a pretty immoral person. You're not very honest. You have all this other money, and yet you're applying and wasting our time and resources, hoping to get more money, even though you're well off already. You bastard. That's basically what they were thinking. They didn't say that. But the thing is, that's the whole intent of a needs-based program. Now contrast that with, in 1964, on the 9th of November, Minister Judy LaMarche was asked a question by a Mr. Chatterton in the House of Commons. So because of that, I have the answer to read now. And he said, if we have a public servant who becomes disabled, and they're going to get the Public Service Superannuation Act disability pension, and they're also might get the Canada Pension Plan disability, is that acceptable? Is it okay for that person to get 2 pensions? And she said, yes, of course. If he has 5 or 6 pensions, he'll get them all. Now, some people might think that's too much money. But think about it. Pensions are property. And if you have 2 pensions, you have 2 properties. So why should one property reduce the value of the other property? Which is the whole idea of bridging. They want to income test a person, oftentimes disabled. And they want to reduce their payment under the Public Service, Canadian Forces, and the RCMP Superannuation Act. They want to reduce their payment under one pension, even though that's the return of your property, because you have another pension. Now, I'll mention this, although I might have it wrote down for a later comment, but it's in my head right now. I was thinking, things cross my mind all the time. I recall things I wish I didn't recall. And a phrase popped into my head the other day: this headquarters has been notified. Now, when I found the letter I got, I had it wrong. It wasn't this headquarters has been notified. It was this headquarters has notified the Public Works and Government Services that you are in receipt of the Canada Pension Plan. Now, that has me awfully curious about what gave them the right to collect that information and who gave them that information. Because remember what Judy LaMarche said in 1964, you're supposed to get both pensions. Now, if you're supposed to get both pensions, then why is it the business of the military, who said this headquarters has advised Public Works and Government Services, so they gave them a directive. So they gave them a directive to reduce my pension, and I'm sure they'd say it's within the Canadian Forces Superannuation Act, Section 15(2)(b). And that imposes a positive obligation for you to inform the military when you get a Canada Pension Plan. And it's supposed to be even if you get denied, I believe. And you see, this is bullshit in my mind because, well, they're not similar programs. It's not like they could say, we're going to use Privacy Act Section 8(2)(a) to justify this transfer of personal information. If I have information about my Canada Pension Plan, which is made of contributions from my career, and pensions are property, remember. So that is between me and Canada Pension Plan. Now, if I have a pension between the military and me, that is between me and the military and not Canada Pension Plan. See? So it's supposed to be personal information. The Privacy Act is supposed to protect personal information. It's supposed to be not that you have to give the government too much information. They're not supposed to ask for too much. Now, I have been curious. I wonder if I signed some kind of consent form when I apply for my Canadian Forces Reserve Force Pension Plan. But you see, it shouldn't matter. They shouldn't be trying to ask for something that violates public policy, because the public policy is you get both pensions. Now, this is not something new, because in 1966, the RCMP Superannuation Act Actuarial Report said that only 10% of retiring disabled RCMP members were expected to qualify for the Canada Pension Plan disability. So because the government at times said to the opposition that we're going to give them both pensions, other people decided to find loopholes in doing that because they thought the government was wrong. They thought you can't get both pensions, that's too much money, so let's impose a very stringent definition of disability so that when they apply, they won't get the Canada Pension Plan disability, so then there's no problem, is there? You get your RCMP or Public Service or Canadian Forces disability pension, but you don't get the Canada Pension Plan disability because they have such a strict definition that nobody gets it. That's the way it's always been. So they had 10% in 1966 and 1974. It went up to 25%. So, you know, I mean, it's not supposed to be like that. Look, if you have a pension, pensions are property. You become disabled. You're supposed to get your pension just as well as if you were healthy and retired. Why should they, anybody who's administering a pension, think that they can treat you differently, in other words, discriminate against a disabled person because they're disabled? It's insane. Adding to the insanity, in the case of a Canadian Forces member, they could be walking down the road in Kandahar during the Afghanistan war. They get blown up by an IED. Then they have their career cut short. So normally you can serve up to 35 years and get a 70% pension based on 2% times 35 years accrual rate, and you can get a 70% pension based on your best average 5 years pay. But you're in service to Canada, you became disabled, and you get a reduced pension because of that disability. Now, the Service Income Support Insurance Plan has been automatic on medical release since 1999. Now, Manulife, as the administrator, forces people after 2 years to apply for Canada Pension Plan Disability. So in order to reduce the government's liability under the long-term disability insurance, they try to get you to get the Canada Pension Plan, despite the fact that it's only a 35 to 40% chance of approval. And if you get it, you get a reduced Canada Pension Plan Disability because you didn't serve 47 years. In order to get a Canada Pension Plan Disability, Canada Pension Plan Retirement Maximum Pension, you had to serve 47 years in the workforce. Now, then, because of bridging, the reduced Canada Pension Plan Disability further reduces the fucking reduced Canadian Forces Superannuation Act. Now, I've been striving not to curse as much, but isn't this galling enough to deserve a fucking curse when these bastards are doing this? Nobody thinks about the effect on the person who is disabled in Canada service oftentimes. They're forced to get something they don't want because they know it's going to harm them. They get the Canada Pension Plan, and then it's a liability, not a benefit. Crazy, isn't it? Now, I was going to talk about a few horror cases, and I'll just mention one or two. What reminded me about this is that I was going through my picture, like I said, and I saw one from a Quebec veteran, a female Quebec veteran, and she got cut off of rehabilitation because she cared more about her family than rehabilitation. She got pregnant. Because she was pregnant, she couldn't participate in rehabilitation, and therefore Veterans Affairs Canada, in their supreme kindness and empathy, they decided to cut off her compensation for her injury in military service. Now, do you think that's fair? I think it's fucking horseshit. Then there's an Alberta veteran who was in rehabilitation, developed brain cancer, and because he had brain cancer and he couldn't participate in rehabilitation, he got cut off. Oh, so you're going to have brain cancer, which I bet you is probably terminal in a lot of cases, and you're going to make that person suffer more financially while they're waiting. I don't know if he died. I don't want to find out. But that's crazy. Absolutely nuts. Okay, so that's two examples. I've mentioned other ones before, but I don't think people understand about the effect the government has on us. And they would say, we didn't do anything wrong. Everything we're doing is legal. Look, I don't care if what you do is purportedly, allegedly legal. Think about the fucking effect that it has on the person that you're doing when they have money coming in to compensate them for something, or if they're getting a long-term disability insurance payment because they bought a contract, bought a policy, and then you decide that your interest in saving money is more fucking important than treating these people like human beings. Now, I'm going to leave it on that note. I got a bit too upset about this shit. But one of these days, I think that they should have to pay the reaper. Because what they're doing should send them hell. Anyway, thanks for watching. I'll see you next week.